Arnold. I'm a lawyer here in Ottawa and a member of Collaborative Practice Ottawa. Collaborative Practice co-sponsored the presentation of Bill Eddy and the High Conflict Institute at a seminar here in Ottawa, May the 13th and 14th, 2013. You're about to see a short video of a panel discussion that occurred at the Institute. I hope you enjoy it.
Hi there. So I am Jefcott. I am the president of Collaborative Practice Ottawa, and we have the pleasure of sponsoring this event with the folks at Magentics and with introducing you, if you don't know about it already, to Collaborative Practice. So we've got a bunch of folk here who do some of that. I am one of them. And we're going to take a minute just to tell you a little bit about Collaborative Practice, and we're going to talk a little bit about dealing with high conflict cases in the collaborative context. So hopefully we can engage you with some feedback to us, and we'll try and answer questions, but we're going to also hear from some of these folks about what their experiences have been like in those situations. And I can tell you that we certainly do see them. For those of you who think that collaborative is, you know, as my colleagues at my office sometimes say, it's a big kumbaya, everybody's hugging. That is not how it works. So, my friend Chris and I went to talk to judges a couple of years ago, and we did a little presentation. And in the presentation, you know, Chris provided a nice quote from a case. Someday, a wise person in a position of authority will realize that a court of law is not the best forum for deciding custody and access disputes where principles of common sense masquerade as principles of law. Implementing the best interest of the child precept requires objectivity, not a legal education. That was a statement made by Mr. Justice Quinn in a case called, and I'm going to pronounce it wrong probably, but it's Jeremiah versus Harb. I have the site for those of you who might like to look it up. So, what is collaborative practice, or collaborative process, or collaborative law, variously referred to as these things? It's a structured negotiation process. It is safe, respectful, and supported bargaining with a safe, respectful, and supported bargaining environment. And it is assisted by specially trained professional team members. The goal is to discover the best possible solution for the parties as they define it. So we're trying to resolve disputes. That's what we do, right? We're trying to do it outside the court. So we are using an interest-based negotiation process as opposed to a traditional one, which is what you see in the adversarial process. And we have a very important piece to our agreement that we all enter into at the beginning of the process, which is the withdrawal agreement. So we all agree that anyone can withdraw from the process, but if someone withdraws from the process, they will not be able to work in an adversarial context with anybody ever. We will not go to court. I will never go to court for a collaborative client. Joyce, Valerie won't do that. We send an agreement that says we won't. Okay? So that's to us, that's the key distinction. The key distinction between what we do as litigators and what we do as collaborators. Okay? The collaborative process tends to take a holistic view. So we're not just trying to deal with legal issues, we're also trying to deal with the emotional, you know, the personal stuff, if we can, as well. And we see it as an opportunity for genuine healing. So what's the team? When we talk about the team, well, the team is a constellation, it's a group of people who are trying to help people deal with the whole group of issues, not just the legal issues. So we have, for example, someone often be providing financial information. We have mental health professionals who are providing help with the emotional issues, again, as a neutral. Right? But the idea is that the person with the appropriate training is giving is giving the advice, is giving the information. For example, parenting is another place where we often have a parenting expert to do that piece with parties, again, as a neutral, okay? And we also offer ancillary services, such as evaluations, real estate agents, coaches, right? Those folks are providing us with help as well, as required. So, as lawyers, we are still advocates. We are still representing our clients, but we are, instead of trying to take positions to help them, we are helping come up with solutions that work for everyone. Our job is to do that, but it's also then to explain the outcome or to draft the agreement and to tell people what that looks like relative to what other options are. So hopefully that's a good enough description to help you understand what we're talking about. I'm going to pass the mic over to my friend Chris here, who's going to tell us a little bit about some screening, and then we'll hear from Valerie and from Joyce, and then Chris again, and then Bill. So we certainly welcome people getting involved in the conversation. That's our goal here with the panel, and I'll look after sort of trying to direct who's going to answer particular questions. Does that work for everybody? Excellent.
Is that okay with you?
Chris? Tell us about screening. Thanks.
So, just to pick up on what Jim was saying, it's a negotiation process like mediation. It has a structure, much more structure than mediation, and its objective is a written separation agreement settling what is essentially the legal issue. But the process itself, the process to get to that agreement, is fundamentally different. So when Jim talks about a process, if you're trying to picture it, I'm a pictures guy, so thinking there's always going to be two spouses and two lawyers. The lawyers are a necessary part. And initially, back in 1990, when a lawyer in Minnesota thought this up, initially, that's what collaborative looked like. It was just two lawyers, two clients, but the lawyers were specially trained to do the negotiations in a different way. As time went on and we matured as a movement, we started to actually humbly say, we don't know everything. We don't rock at everything. And in particular, about the emotional side and about the economic side. So that's when we decided to open up the sides of the tent and invite people who did know a lot more about this stuff than us, our mental health people, which, by the way, here in Ottawa, we have clearance from our mental health people to call them mentals. So if I say mental, if I use the word mentals, don't get your back up. Please, it's said with love and respect. And we have financials, and we're just the legals. We're just another member of the team, but that's what we're taking care of. So as I say, as a movement, 1990 is when Stu Webb, the lawyer in Minnesota, thought it up. 2001 is when it came to Ottawa. So we have a 12-year track record here in town of doing this work successfully. But initially, my topic is screening. Initially, like Bill said, who stole a lot of my talking points, thank you very much, Mr. Eddy. Initially, we were focused on who should we screen out? Who should we prevent from doing our little thing here? And initially, I'll be blunt with you, we were worried about quality. We wanted our thing to thrive, so we wanted successes. So strange high conflict people who were going to likely implode, we would say, oh, that doesn't look like it's appropriate for a collaborative. Just go over there to the courthouse, would you? Thank you very much. Don't let the door hit you. So, as time went on, we realized that the process, given its flexibility and the help from our other friends in the tent, we could, in fact, did have a better place for a lot of these conflicts to come and be resolved. So, eventually, we started to screen in and screen out much less, much more confidently saying, as Bill said, why aren't we asking where we're screening them to? No, you can't do collaborative. Get out of here. Go over there to the warm, loving embrace of the courthouse. Wrap yourself in that snuggly little restraining order, and everything will be fine. And the cold, hard reality is every day we read in the paper about how it's not fine. And so we started screening in, and when we started saying this is appropriate, we started then having the desire to say, but we gotta do team. Two lawyers who have a great deal of family law experience, because all of our lawyers do, we realized that those two people are not going to be sufficient to support this transitioning family through to a resolution. So, yeah, I think we screened in, and then we're basically screening to determine what our process has to look like. The sort of knee-jerk reaction was, we need help from our friends, so come on in, and it was almost a precondition. Yes, we're ready to do collaborative, but we need a team approach, period, full stop. No, we just want lawyers. Well then, no, we're not interested. Thanks, have a nice day. And as a mature movement, with mature, experienced professionals, we were much more willing and capable of doing that.
Can I just say, though, that the screening in doesn't mean that we don't pay attention to things like safety and things like making sure that people are comfortable and they feel secure. In fact, part of our process is the professionals speak together before we meet to have the conversation about what we need to do to make sure that everybody is comfortable and the process is going to work, that it's not going to be held up because of some practical or logistical issue, right? So, someone who's concerned, for example, about a spouse who's going to maybe give looks, or who's going to, use body language that's going to, mess up the situation. Those kinds of concerns. Where do we put people? Where do we have the meetings? How long are those meetings? Things like that. We have that conversation before we have the meetings with the group. Okay. So I'm going to pass it along now to Valerie, who's going to talk to us about the role, in some senses, about the role of the mental health professional, or what we call the family relations professional sometimes. Valerie?
I was just going to say, we sometimes are called mentals, but more and more recently we are being called family relationship specialists. So before I talk about my role, though, I just want to put in a little plug, because I am the head of the training committee. If this is a process that is interesting to you, we are holding a level 1 training, so learning about the basics of how to do collaborative law. It would be May 30th and 31st in Rockland. So it's an excellent training. I'm leaving at the break this afternoon, but if you have questions about it, you certainly can come see Jim. And Colleen Curry is one of the trainers, and I think she has sneaked out to do a little shopping. I've just told on her. But she will be back, and she's sitting over there, so if you have questions, certainly go and see one of those people, or anybody else on the panel. So just briefly, I changed my practice just under a year ago. I no longer do individual or couple therapy in the context of what I used to do. And when I was a marital therapist, my supervisor was Dr. Brenda Sachs. And one of the things that Dr. Sachs used to talk to me a lot about was the 5 horsemen of marital conflict. And so I'm just going to go over those 5 horsemen and how they relate to conflict in separation. We have acrobatics over here. Let's talk about sex for just a second. Get everybody interested in that. One of the things that we know in doing marital therapy is that arguments about sex are very rarely about sex. They're about the deeper need for connection and the need to feel loved. And so for people in high conflict or high conflict personalities, that need never really goes away. Okay, so some of the issues that come up around the issues of sex in separation are the same things that occur during the marriage. If there was an infidelity, that can remain very much an area of conflict. The person who was cheated on often feels that they're owed something. And so my role in that is to help them get beyond that. We're not doing therapy in the collaborative process, and sometimes I will refer people out to individual therapists. But the role is really to get them beyond the big intense emotions so that they can work on a separation agreement, because that is the end goal. One of the other horsemen is in-laws. We call them the Greek choir. Okay, you can call it the French choir, the Italian choir, you can call it whatever you like. But the idea, and again, with high conflict people, is that they're always trying to draw everybody in on their side. They're trying to bring in more people. The nice thing about collaborative is we don't often talk to collaboratives. Okay? I won't often go seeking information from other people. So it eliminates their ability to create this huge amount of people who are all taking their side. And the nice thing about collaborative as well is that we're neutral. The financial person and I are both neutral. So we're not taking sides, and we're keeping them on track. One of the other areas are household duties in marital conflict. Pardon me. That can also go into the household stuff once a couple separates, and that remains conflict. Johnny's not getting a bath when he goes to daddy. You know, mom doesn't know how to do this. They're not getting their homework done. And those are the areas that I can help them move past so that they can come to an agreement. The final area that I'm going to talk about is children, because that's for many of the couples that we work with, there are children involved. And so I help them to bring together a parenting plan that works for their family. And it's different in every case. And I work really carefully with them, often what we call offline. So I'm working with them outside of their lawyer's presence. First of all, it's cheaper for them to work solely with one of us as it is to have the whole team together. And also, they just don't need to have their lawyers present for all those discussions. Okay? But it's very much about pulling together a parenting plan that works for them. And that's a big part of what I do. I also facilitate the meetings. So I'm the one who keeps everybody on task during the meetings. I'm the one who takes breaks. If there's emotional stuff going on, I'll call for breaks. Might take somebody aside and kind of help them calm themselves down. The last horseman, and it's not one that I deal with, is finances. And I'm going to pass the talking stick over to Joyce because that's her expertise.
So, to carry on with what Valerie said, having a neutral in the room in these meetings, we create a zone that's safe and that encourages conversation that might be difficult if a neutral wasn't present. Especially when you're coming to finances, we usually find that one spouse might be financially naive as compared to the other. There's a power imbalance, and so you could have one spouse who's dealt with all the finances, the other one really didn't pay checks, do the bills, doesn't have a clue. And coming into these meetings when they're discussing options that are crucial for their financial future, and they don't have the confidence in themselves to ask these questions, having a neutral in that room helps them to ask those questions. The neutral, the financial neutral, is also able to educate whichever spouse needs educating, and helps them to have conversations that are productive, and helps them to come to resolution. The other thing, having a financial in the room also makes creative solutions something that will happen, because a financial has experience that can be that's different from what a legal professional or a mental health professional will have, and they can use their experience to help the clients come to solutions. Now, the important thing is that the financial will point out options, help them to come to resolution, but in the end, it's the client who will then decide what works for them and for their family. Having a financial as well helps them, helps the process to be more cost effective and more efficient, and helps to bring resolution.
Let me just take a second and echo what Joyce is saying in a practical sense, in that the first time Joyce and I worked together, she has these great little charts that she uses, that she creates after she takes the financial information and she plugs it into a spreadsheet. And she has these really great little graphs that show us over a period of time, what does the financial situation look like if we make, choices between option 1 or option 2 or option whatever. And the first time we used her, she came in with these, 2 options with the direction of council and with the direction of the clients. She came in and the graphs were so clearly, either positive or negative. The positive one was such an obvious choice when we saw it that it settled immediately. Once we saw the graphical representation of what things would look like if we had made that choice. So that just, to me, says it all in terms of how the financial can be helpful to us. So, right. Bill, did you? My thought was that Bill would be our last speaker. I'm going to turn it back over to Chris for just a second to talk to you a little bit about what the legal professional does in the process, and then we'll go back to Bill.
Okay. Thank you. So, a key element to take away, if you understand that the focus of the collaborative negotiation team is to create a safe bargaining environment. Just to go back and run over it again, what Jim described earlier in our participation agreement, like a mediation agreement, all parties sign. The participation agreement contains a disqualification provision. That means it's more binding, if you like, on the lawyers. In the rest of the language is all, kind of fluffy, mom and apple pie, we're going to share, we're higher intention selves, yada yada. It's all very nice. What really is binding is on the lawyers. We agree in a contractual, enforceable way to withdraw if anybody litigates. Means if my client says, screw this, I'm out of here, and starts a court action, I'm off the case. And for example, if Jim was the other lawyer, so would Jim. Now lots of people say, oh, that sounds terrible. That sounds like it's open for abuse. People will just pull the plug to get rid of both lawyers. Doesn't that sound wonderful? Well, yes, you can get rid of both lawyers, but you get rid of your own lawyer too. The key element is, that is the safety. Now when I'm sitting in the room, the other spouse, not my client, their spouse, doesn't see me as an enemy. I'm never going to cross-examine them in court. They have no disincentive to share with me what's important, what matters to them. I also then am fully participating as a brainstorming piece of this 8-headed or 6-headed, 4-legged or 12-legged machine. Right? This has one objective, to get to a resolution that everybody finds acceptable. So that safety, the fact that the lawyers can never litigate. I also, now what's my incentive? Do I have an incentive to make it any worse? Do I have an incentive to run it into the gutter? Because if I run it into the gutter, I go and see Donald Trump in the boardroom, and you're fired, right? I'm fired. So I have an incentive to create the preconditions for a successful resolution. So suddenly my incentives, my objectives are aligned with the clients. So that safety, just to maybe pull the lens back a bit and connect with the seminar that we've come for, how many things did, I was here just yesterday for the morning, but as Bill walked through those 5 personality types, and blah, 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 this is about the fear of something. Blah, 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 this is about the fear of something else. So we have 5 high conflict personality types, all keyed off of fear. So if I have, and I'm running a negotiation process that is keyed on safety, the safety, when massaged in a particular way, can likely address, or at least be in a conversation with, those fears. Which is not about fixing those people. Thank you, Bill, for relieving me of any obligation of fixing these people, because I understand that they're not fixable. And I thank you also for relieving me of any obligation of diagnosing these people, because I can't figure them out. They're just screwed up. Or they just drive me crazy and I don't know why. I don't have to do any of that. I just have now some new tools in my toolbox of how to help myself work with them. But in the collaborative context, I have an incentive to help them reach a level of functioning, right? The fantasy that there's a perfect functioning divorcing spouse, I've given it up long ago. They need a sufficient amount of capacity to be able to make decisions. That's lower than you might think, right? They need to be able to understand information and give instructions. So where is that line? That I have some obligation as a lawyer because I can't take instructions from somebody who has no capacity. That I'm sticking my liability neck out there. But with the addition of my teammates, who now I have a much more nuanced view of whether the individual is functioning or not, and it creates a much safer place for me.
Just on that, let's not forget that the clients are part of the team too, right? So we are not the only members of this group. The clients are fully engaged, and the intention is that this is a client-focused process. We want them to make their own decisions. We're there to help them. We're there to give them legal advice. We're there to give, perhaps, help generate options. And by that, when I say we in this case, I mean all of us in the team, right? But we're not there to make the solution or to create the outcome for them. So maybe I can pass it to Bill, and then we'll open it up for some questions and comments. Thank you very much, Bill.
What, about 5 minutes?
Yeah.
Okay. Is this on?
Yeah.
Okay. I think what I'm thinking, since I don't disagree with anything they've said, is to give you 2 examples of cases that I was involved in that were collaborative, in which I think we had a high conflict personality. These were 2 cases where we thought we had a reasonable person and a high conflict person. I was, of course, the attorney for the reasonable person, in my point of view. But I'll tell you how this worked. One, I'll focus on financial issues and how the process, I think, was helpful because of the dynamics of this case. My client was the wife, and the husband was an accountant, and he made pretty decent money as an accountant, but he never shared any information about their finances with the wife. He was also a bit verbally abusive, and for much of the 10 years before they separated, my client told me they lived in the house but didn't speak to each other. They had 2 teenage children, younger teenage children, by the time they separated. And she was very nervous about everything, what to do, how to make decisions, etc. She may almost have been a dependent personality. And you have to watch out if you have a dependent personality client, because they're going to want you to do all their thinking. And you need to especially give it back to them. But what happened in this case is she knew nothing about the finances. And so what we decided with the team is we would have a couple sessions where the husband would bring all his financial documents that were required by law to be shared, and others about the business, his cash flow. We didn't even know what to ask for. As a lawyer, I don't pretend to be a financial person. As a judge once told me in open court, he said, "Mr. Eddy, if I wanted to do accounting, I would have been an accountant. This isn't for me, I'm a lawyer," says the judge. And we both agreed we weren't accountants. So we need accountants to do that, financial people to do that. So in this case, the financial neutral said, here's the documents you need to bring to a session or 2 sessions to explain to the wife how your business works, where the money has gone over the years, etc. And so we had a couple sessions with writing on the walls and flip chart paper on the walls and explaining all these things, looking at tax returns, one document after another, with the financial neutral really, in a sense, as an intermediary between the husband and the wife, explaining, okay, this is how that's working. My client felt much more comfortable asking the financial neutral to explain how things work. By the time we were done, my client from the start told me, I'm concerned he's hiding money. He's put money away, and he likes to take trips, and he actually owned a half interest in a small airplane and various things. And she said, I think he's really rich, but I'm not sure. And since they've been living together for 15 years, something like that. She had some idea of lifestyle, but she didn't feel confident about him, very mistrustful. By the end of these 2 sessions, she said, I think I get it. There's a lot of money that came and went. There's a lot of money we're not seeing sitting in the bank. And you know, with someone who doesn't know anything about the business, they often imagine the person with the business has a lot more money than they have, on the one hand. Or maybe the person with the business has really stashed money away and knows how to do it. So by the end of these 2 sessions, I met with my client and I said, so what do you want to do? You really got choices here. We could proceed with what you have. We could ask more questions. Or you could stop the whole process, hire separate lawyers, and go to court, do lots of discovery. Get all his bank records that he's not giving you, if they exist. You could do this, 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 and this. And what she said to me is, I think I'm satisfied. Now I understand how our finances operate. I'm not positive that he didn't hide some money, but what I'm positive of is we're not going to find it if he did. And so rather than prolong this unnecessarily, I'd like to move on to settlement. And she said, because I trusted the financial neutral, I was willing to stop the process. That's what she said, and I felt comfortable too. You'd be good. Happy to know that. We trust our financial neutrals, as well as our mental health. And lawyers.
Yes, another story.
Big part.
You were ready to tell us another story. No, it was 2. You were 2 examples?
Yes, let me get to the other one. Well, let me just quickly, on the end of this, he was also verbally abusive with her. And in some of our group meetings, he would reject what she would say and her proposals. So to end the case, we had a carefully orchestrated, and this is where the mental health professional comes in. In this case, each party had a separate mental health professional, although I think nowadays most cases just have one. And we carefully orchestrated our last meeting. My client needed to be heard and needed to be respected. So the coach and I talked over with her what she needed to say in that last meeting. We then communicated with the lawyer and the coach for the husband and said, my client needs to say these things. Your client needs to keep his mouth closed and listen. And then he needs to say, I hear you, I respect what you're saying. If you can get me that, I can get you a settlement. And so we had this carefully orchestrated meeting, and my client basically said what she needed him to hear. He listened to her, and he said, I respect what you're saying. By the way, this is a case where we had a 6-month break a couple times. And he became ready to do that. And the case settled. And we could have gone, if they were in court, they'd probably still be going now. So that's that case. The other case is very brief. I think probably a borderline traits person on the other side. Everything is done, and we have one last meeting to iron out some small details, and then they're going to get on to signing their agreement. I don't know what happened the night before, but when we came in and sat down, the wife started screaming at the husband. She burst into tears. She was a mess. And we all looked at their coach and said, okay. And they said, okay, we're going to take a break. They went out for a lawyer, and the coach went out for about 5 minutes. They came back, and then the case settled. So it really helps this. That's some of the aspects of the team approach, is really helping each other out. It's more than I can do as a mediator single-handedly, and that's part of the beauty of the collaborative approach. Thank you.
Okay, so hopefully we've given you some stuff to get your thoughts moving along to questions and comments, and we'd be happy to hear from you. So back over here.
I was just wondering about the transition as lawyers from pre-CFL thinking to, and I'm sure that you had that sort of epiphany of some sort that you want to do something different. But I mean, in terms of from acting solely in your client's interest to getting a resolution, I'm wondering how it was for you as lawyers to make that transition, because the second part of the question, excuse me, relates to lawyers that advertise as CFL.
But aren't.
But aren't. And I'm just wondering about that protocol piece, the agreement.
Sure.
Is that a requirement?
Yes.
It is a requirement.
So that's what we call the paradigm shift, right? So making that shift from the adversarial perspective to the collaborative perspective. It is difficult. I can tell you, I went through it because when I started, as many of our colleagues tell us who are not collaborative, oh, I collaborate all the time. Right? And we thought we did. Right? And then we learn the skills and we go through the process and we do some of it and it's like, oh, maybe there's a few things I can learn. I'm going to pass it over to Chris, who, by the way, I think has made a wonderful shift. If he had to make one at all, he's one of our real good practitioners. So I'll let him talk a little bit about that stuff, then I'll come back and tell you a little bit about our, well, maybe Chris will do that, what the agreement says.
Yeah. So just to answer the second question first, the collaborative participation agreement is signed or it's not collaborative, period, full stop. Anything else, oh, well, let's just get in the room and, roll up our sleeves and see what happens. That's cooperative. We are cooperating with one another. In the absence of the collaborative structure and that participation agreement, it's not collaborative. So this goes back, remember I said we were kind of defensive about wanting to get things to succeed? We're also defensive about having people call it collaborative when it ain't. So, yeah.
Is it conceivable for lawyers to be both collaborative and adversarial? I mean, I know you're into...
I have a colleague named Nancy Cameron who says it's like riding two horses. You can do it, but you can't do it well for very long. So, yes, most of us, just because of the reality of the market, we can't exclusively collaborate. We can't just say, I'm just going to collaborate, unless you also want to just give up your home and lifestyle, etc. So, the paradigm shift is tough. In fact, what's interesting is I've been teaching now collaborative to third-year law students for now 7 years. So these are little baby lawyers. They haven't even practiced at all yet. And yet by the time I get them, they've already had so much advocacy and confrontationalism and adversarialism pushed into their bones that they sit there like deer in the headlights for the first couple of classes going, what is that going to say? How do you use that? Good. How do I get what my client needs, There's a deep ego boost, speaking to my mentals in the room. There's this deep rush of adrenaline when you take on somebody's problems and fix them for them. Isn't that awesome? Aren't I great? Except the downside is rarely do you actually understand anything about what this individual truly wants, short, medium, or long term. So the paradigm shift is really tough. There are people who have trained, who are members of our group, who fly the flag. I'm a collaborative lawyer, who I literally wouldn't sign a participation agreement with. That's something we're struggling with as a group, and that's a journey we're still on. But it's tough. It's tough because it is a fundamentally different way of thinking about client representation. It's really about client empowerment and about helping the client in various different ways and just not solving their stuff.
But one other thing is that we can model our behavior, right? So when I have a collaborative lawyer who ain't so collaborative, I will say to them, let's have a conversation, right? Let you and I talk. And, I offer to mentor and I offer to, do debriefs, which we should do, not always, but we should do after each session. And so that sometimes works as well. We model behavior.
We're live coaching.
Exactly.
Yeah.
Right. So, another question?
In terms of research, has there been any long-term research done on, yes, you reached a settlement, but how has it broken down over time, or has the settlement been fairly successful? Is there any research past that, past the settlement?
Bill, do you know?
There's starting to be research, but
Sure.
there's starting to be research about the method. I don't know that they've broken it down with what percent settle, what percent don't, but those statistics are getting gathered throughout North America. There's the International Academy of Collaborative Practitioners, Collaborative Practice, IACP, is trying to gather more data because it's been around really active for maybe a dozen years. And so they are starting to do some research on it, but I don't know if they have all those answers yet. But by and large, it's been very successful. The question is it successful because of who uses it, who's attracted to it? And what's interesting, mediation, which has been around maybe 30 years active in family, at first only had people that were really great for mediation. They usually all settled. Now we're getting more and more of the high conflict cases, but collaborative's also getting the high conflict cases. To me, the ideal research would compare to the court process versus collaborative. And that's where I think you'd see the big thing they know is people are much more satisfied.
Yeah, when we talk about the durability of an agreement or the enforceability of an agreement, it's a truism that we can all rally around. If a person is more involved in the resolution rather than having it imposed on them, your enforcement issues dramatically drop off because they participated in something instead of having to force them. Right? So that's, we try to then, the model is built for maximum participation of the clients, which very frankly makes it easier for us because they're deciding on us.
Joyce, did you want to add that?
I think we have some of the questions.
I just wanted to ask the cost of the service.
It varies from case to case. Again, depends on how many meetings they are. But personally, I do think it is cost effective because what we find here in Ottawa is that there are a couple of offline meetings held where we're using the client's money efficiently. For instance, where the financial, myself would meet with the couple of my office, so that's only my fee there. And the mental health professional would do the same, meet with the clients off-site. So we are saving time and money in that way, and I think the long-term results, of course, compared to going into court, I would think it's definitely less expensive and more cost-effective.
Anything?
No, nothing really to add.
So just, I can tell you that what drives cost for us is complexity and complication. And so can I tell you that it costs more or less than another process? No, I cannot. I charge less to do collaborative because I favor collaborative. So I tell my clients that. I'm charging you less because I favor this process.
Because you're not a real lawyer. If I was charging you like a real lawyer, it would really be
but we can't talk about specific. I can just tell you that it's about efficiency and doing things and avoiding spending time on stuff that we don't need to spend time on. So when I can say, when somebody's having a freak out about some situation, why don't you go talk to Valerie for a few minutes, right? And we get past that issue and then we come back and we talk resolution, that's a huge cost saving.
And we're the most expensive place, right? By hour. So yes, what does it cost? It drives up by conflict and complexity. So you want to fight about the salad bowl for a few meetings, get ready to pay for large amounts of professional fees to fight over the thing we could have purchased 75,000 times over. But as things are pulled off of these expensive plates to these still costly, but still, they cost money, they're professional services, less, you're only paying one professional fee instead of two professional fees to talk about what we don't really have any professional training to do. So,
Janet, I think you had something, and
Yeah, I just wanted, is there like a group that's the Collaborative Practice Ottawa group? And
yes.
How many are them, and how many lawyers, how many mental?
We're running into about 90 people now. We're about 60 lawyers. We have We have 4 mental health professionals, we have 5 financials, I think it is, and the rest are what we call general members, and these are people who are interested in collaborative, but who are not necessarily engaging in the negotiation process, who are providing ancillary services or who are providing support. So we're about we are the 2nd largest in the province of Ontario, not far behind Toronto, and we're very actively involved in the provincial group, which is the Ontario Collaborative Law Federation. So yeah, so we're a big group. We're a big group. I'm just worried about time. We maybe haven't had time for another question, and I'm going to have to leave it to conversations after. So go ahead. Yeah,
I just want to know, is there any particular training or licensing, and how would clients know who is collaborative, who's adversarial?
Sure. Valerie will take that one.
As a matter of fact, we do have a training coming out May 30th and 31st.
I was kidding a little bit.
Thank you very much. We have the mental health professionals have to do a level 1 training. So everybody does the level 1 training. Okay, the lawyers and I believe the financials and the general members do the level 2.
Anybody who wants to be in the negotiation has to do or has to show us that they have an interest-based negotiation skill set. So this level 2 is interest-based negotiation. The level 1 is the basic collaborative training. So if you want to be involved in the negotiation exercise, we require that you have interest-based negotiation training as well as collaborative training.
And we run the level 1 training usually once a year, and then we do level 2 training. It'll probably be in the fall. So we do each of the trainings at least once a year. This particular one we're doing in Rockland this time because we've been asked by a group of lawyers in Prescott Russell. They really want the training. There's somewhere between 6 and 12 who have indicated that they'd like to be trained. So we're trying to accommodate them, and we're running this particular training in Rockland, but it's generally in Ottawa. Colleen, now that you're back in, could you just stand up so that if anybody has questions? Colleen's one of the trainers for the level 1 training. And if you have questions, certainly you can go and see her, or you can come and see Jim.
If you're really on fire to do it and there isn't local training available, you could write down these letters, oclf.ca, Ontario Collaborative Law Federation, oclf.ca. There's a tab there called training. You can find training and pretty much all over Ontario, so you wouldn't have to wait very long. If for whatever reason you miss an Ottawa training, you don't have to wait 12 months. You might be able to go to Barrie or Kingston to pick up other training. The advantage of doing it locally is if you're often training with people you'll then be practicing with. So you then begin to make those professional connections that eventually build into professional trust, which is something that is kind of the magic of this model. We begin to work together, and for example, Colleen and I had a number of cases together quite recently, such that there's such an immense level of trust and respect between us that we can help our clients. We model a kind of a behavior that really serves them very well. And the paradox is, in a collaborative case, you want your spouse to have an awesome lawyer. As opposed to in a competitive litigation environment, you hope they hire the greenhorn right out of law school who doesn't know which end of the law book is up. So in our case, it's a good thing when your spouse hires a good collaborative lawyer.
You want anything to go on that, or you? Okay, well, I think we're going to have to end it given time constraints, but we're all happy to answer your questions after today's session or at any time. We do have some information behind the panelists. There are brochures there, and there are some cards with our website, and we're bilingual. We have bilingual practitioners in each of these skill sets. So if anybody has questions, like I said, come and bug us after, and we'll be happy to answer them for you. Okay? Thanks very much.
Do you ever have a multicultural interpreter, or like it was for another culture?
I have not, but there certainly, I would say probably some of the folks in Toronto probably do that. Not so much here, but I'm sure that's going to be an issue. We're certainly talking about cultural diversity and that kind of thing in our. We don't just train to do this, we also do ongoing training. So we're looking at issues like that. Thanks very much.